Greetings. This is Della Welch, attorney at law in California. I have some information about the Miranda decision. These are just general guidelines or tips and basic information. If you have the need for a lawyer in this area, you should seek your individual counsel. This is in the area of criminal procedure. And this is the Miranda versus Arizona case that was decided 51 years ago in 1966. But it's still good case law today. However, there are a few exceptions kind of chipping at the Miranda decision. But this refers to like the Fifth Amendment, that you do not have to incriminate yourself out of your own mouth. You don't need to incriminate yourself. The Miranda warning is in 4 parts. Some police agencies, they actually have Miranda cards that say what those 4 questions are, or some police officers remember that. I remember teaching a class, and I was giving the lecture on the Miranda case, and one of my students told me that he and his mother had been in jail that night. He said what happened is some gang members had punched them, but the police hadn't seen that. But what had happened is when the mother and the son punched back, the police saw that and they arrested them. In the morning, after spending the night in jail, my student who had had my lecture on Miranda said, "Your Honor, my mother and I were never Mirandized." And the judge looked at the police officer and said, "Is that true?" And he blushed a little and went red. And he said, "Yes, Your Honor, I forgot my Miranda card." So my student said, "Boy, did I get a lot out of your Miranda lecture." So knowledge is power. So that's very important. So the questions are, number 1, you have a right to remain silent. I always say if you're being interrogated, you want to remain silent. Sometimes the interrogator, the police, they're not your friends. They may be seeking an admission, they may be seeking a confession, and the worst thing you can do is speak. Number 2, anything you say may be used against you. So if you make an admission, if you make a confession, it may be used against you. You have the right to an attorney. And number 4, if you cannot afford an attorney, one will be, not may be, but will be appointed for you. And so this is important, that if the state wants to prove something against you, let them be the one that does the work. Don't you, out of your own mouth, make admissions. Now, courses in criminal procedure discuss this. Here's a question. The government has the burden of proof to prove a Miranda warning, and that is true. The Miranda warning does not apply to a suspect who is interrogated outside of custody. That's true. It must be by a policeman in custody. A defendant was effectively in custody when the police awakened the defendant at 4 a.m. and he was questioned in his bedroom by 4 police officers. That's true, because he's not free to go. It's early in the morning and here are these 4 police officers. So that is essentially a custodial investigation where he does not feel free to go, and these are police officers. Physical evidence of a crime is not protected by the Fifth Amendment. That's true. Suppose there are tax records by the corporation. Well, the tax accountant of the corporation doesn't have to testify against himself, but the actual records can come in. The records do not have a Miranda privilege. For example, a subpoena served upon accountant to produce taxpayer records does not violate the Fifth Amendment. That is true. Next, a confession that is obtained by physical force is not voluntary. True. You may see a lot of these criminal shows and they're beating up the alleged criminal and making him confess. Well, that's not free and voluntary. So that cannot be used if physical force is used.